Lordship, may I be permitted to mention?
All inclusions, give the slip.
Lord, this matter was directed to be listed today, my lord. Matter is not appearing, my lord. Kindly recall I mentioned on Monday. Lordship fixed a date today.
So one matter was appearing on day before yesterday, Lordship, that WBCT matter, instead of it's called failed from your Lordship, that wrongly WPAST file came. Lordship, today which was supposed to appear, it's not appearing in the list. WBCT 220.
Just make a note.
Lordship,
That matter was wrongly listed.
তো পুরো ফুল ফাইল চলে এসেছিল লর্ডশিপ, বললো আজকে সিটি এসটি চলে এসেছে সিটির জায়গায় WBCT.
Lordship, execution proceeding has been pending before the learned court below, and the date is pending on 9th November, 9th December. So, my lord,
Why are you mentioning here?
my lord, the WPCT has already been filed to challenging the impugned order. And
WPCT in respect of execution.
no, in respect of the original order.
What do you mean execution?
Execution, sir, the matter is related to the service benefit. So one order has been passed by the learned Armed Force Tribunal, regional bench, Kolkata. So challenging that order, petitioner has filed this WPCT. Execution proceeding has been filed by the applicant. So the petitioner will suffer adverse order, my lord, if the matter will not heard tomorrow.
What do you mean execution? We are
Execution service benefit, because learned court below directed to pay some amount to the
that
applicant.
no irreparable injury will be.
Lordship,
My lord.
Give.
Lordship, the petitioner will suffer adverse order,
Yes,
Lordship.
it can always be rectified. It's not irreparable. Yes.
My lord, this matter was mentioned on 25th of November 2024, yet the file has not been sent into the requisition. The lordship, this matter needs to be urgently heard.
This was mentioned
It was mentioned on 25th November 2024
for
for inclusion in the list.
so it will come. We have said in the monthly list it will come. Yes.
My lord, your petitioner is a senior citizen of India, and just now I am filing an application, MAT, tender of mandamus appeal. This matter already released from Honorable Justice Court of Kapo Prakash Chakrabarty and Honorable Justice Sen. This matter already is signed by Honorable Chief Justice. And just now I'm mentioning file is here, my lord.
Give it.
And
We'll check.
now I'm mentioning.
Give
this
it. We
matter.
will check. We will
Check
check.
and-
Give it. We will check.
Item number 1.
I'm for the appellant, Lordship.
You come on Monday. Same meeting.
Lordship.
Adjourn to give the date of Monday. Under the
Item number 2. Another down for the petition. Will the service. Will the service. Well, definite of service. Well, in this matter, Lordship, the order of the tribunal, Lordship, whereby it was directed, I prayed for the interim order, but that was not considered on the day when the order was passed. Lordship, kindly come to the certified copy. The
Interim
next
order regarding what?
interim order regarding the impugned order, operation of the stay of the impugned order. Impugned order, by virtue of the impugned order, I have been redesignated. I was initially appointed and designated as the specialist doctor at Canning Hospital. Thereafter, Lordship, suddenly, by an order, I have been redesignated as a non-specialist doctor. That was the challenge in the original application. Now, original application was taken up
In
for
the same hospital.
in the same hospital. Now, the order appears to be illegal.
Where is that order?
Lordship, kindly come to the impugned order. Impugned order is in page 116. My name appears against the serial number 2. Lordship, Dr. Tanmoy Roy, medical officer. Now, I have been redesignated as a ER outdoor, and this order was passed on 28/10/2024. And Lordship, now kindly come to the notification where I was appointed as the doctor with this specialist doctor. Lordship, kindly come to page. Lordship, page 59, this notification starts, and my name appears against page 75. My name is there. Page 75, bottom. A memo is mentioned. Memo dated 24th December 2021. The governor is pleased to appoint Dr. Tanmoy Roy of West Bengal Health Service Medical Officer on duty to act until further order as medical officer specialist, blood bank at Canning SDH South 24 Pargana in existing vacancy with immediate effect. Now, I was appointed as a medical officer specialist, blood bank at Canning SDH. This was on 24th December 2021. Now, Lordship, kindly compare it with the order 116. This is issued by Superintendent of Canning SDH Hospital. Now, they are saying it's an internal arrangement. Now, the question is that whether by virtue of an internal arrangement, this person can be redesignated. That was the question. However, Lordship, the learned tribunal, while considering the interim prayer on 26/11/2024, recorded everything.
What does ER mean?
Lordship, emergency, Lordship, emergency outdoor.
So you don't want to do emergency duty.
I am ready to do it, Lordship. The
Yeah.
only question I am concerned, I'm being a doctor, I have to do anything. Now, only thing is that I am only concerned with the redesignation. It should not be affecting my service. And I want an interim order to that extent. If your Lordship directs, protects me, I can join there.
Oh, you have not joined.
Lordship, I went to join.
28/10.
Lordship, I applied for the leave. I had the leave. Lordship, kindly allow me, I will join today itself. We have joined, I went to join, but I was not allowed to join. Lordship, kindly.
Don't want to encourage such doctors.
Lordship, today itself I will join, Lordship.
Should have joined.
I
You have
will
been
join.
depriving the public for the last more than a month
Lordship,
from
kindly.
the services. What is this?
Lordship, kindly,
This is too much.
kindly.
You have been employed in emergency duty and you are not even joining. And you are before the court. Where is the question of
Lordship,
redesignation? A job has been assigned to you in the emergency
I will
outdoor
do, Lordship.
and you are not taking up
Today
the
itself I will
assignment.
join, Lordship, kindly.
The tribunal will consider.
Lordship,
There's no
kindly,
scope
without
for
prejudice,
passing.
let me
Sorry.
join. Kindly record that, Lordship. I'll I will join.
The learned counsel for the petitioner submits that the
Interim relief also, Lordship kindly
issues,
mentioned.
all issues, including interim relief,
And,
all issues, including
and
interim
Lordship,
relief.
I may be permitted to join, Lordship, kindly direct.
We have said that you are submitting, you will go and join. You join. We don't know whether
Lordship,
they will
we'll
take action against you. Why you are not there for the last 1 month?
Lordship,
They may be, we don't know. This is a doctor behaving this way. Very peculiar.
grateful, madam.
And affidavit of service kept with the record.
Yes, affidavit of service kept on record. Disposed of, yes.
Item number 3.
Item number 3, Mr. D.N. Rai, like senior counsel appearing. He could not come to court, madam. I am praying for not today, madam.
But yesterday my learned friend did not appear. Last
Ah.
week my learned friend did not appear.
Only for the day, madam.
Prayer is made for adjournment.
Item number 4.
Maybe something that you are in capacity. Join the post of surveillance. Then the
Milord, the petitioner was a mechanic under the Mill Commissioner, Government of West Bengal. Petitioner was a mechanic under the Mill Commissioner, Government of West Bengal. Milord, in the year 2000,
Oh, mint, at the mint. Yes.
in the year 2012, a gradation list was published. Milord, my lord sees that is
When the gradation list was published?
in the year 2012,
Final or provisional?
final.
2012.
On 1st December 2012.
12.
All right. Yes.
Milord, at that point of time, reasonably, my case was not considered, no question does arise because there are so many seniors. Milord,
No, you were in the gradation list.
Yeah, I am in the gradation.
Why do you say not considered?
Not considered at this point of time as per vacancy. Suppose there were 15 vacancies, that's why I was not considered, but I was under the impression that later on I will be given an opportunity if some employee would be
No,
retired.
the gradation list was published for what purpose?
For promotion to the post of senior mechanic.
Senior mechanic. Okay.
Senior mechanic.
So you were not given the post because you were below on the list. Yes.
At that point of time. Milord, in the year 2015, according to me, no less than 14 senior mechanics either retired or expired. Then my impression was that reasonably I would be within the 4 or 5. That was not considered. I moved an application before the tribunal. Before hearing in the tribunal, my learned friend's client on behalf of the state is.
So once you filed an OA, you withdrew it and then again you have filed an OA.
And that's right, then I'm good at.
So let us come to that first, then we'll come to the merits
Then-
of the matter,
then-
whether you can do so.
My lord, then please seize the order itself. Pass
Yes,
by.
we are looking at the order.
Order pass by.
Yes, we are looking at the order.
This question arose at the time of hearing before the other case.
Yes, how can you repeat file successive
Like that.
ways after withdrawing one?
Yes, my lord, my lord, I was relying upon a judgment of the Honorable Supreme Court. My lord, please seize. I was relying upon paragraph 19 because it was not heard.
Where is the judgment?
Yes, I'm showing you, lordship.
Give us.
I'm giving.
The citation.
Citation, develop. Supreme Court.
AR na SSC.
Where is the order passed in OA 1042 of 2015?
My lord,
9th January 2018.
2018. My lord, I was relying up. Paragraph 19. AIL 1961. Huh? 1961. 61. Huh? AIR 1961. Yeah.
278. No, 1457.
Paragraph
19. My lord, shall I read? নেই তো একটা করতে পারছি
ওইটা তাই না? ও বাজারের প্রশ্ন।
Yes. Withdrawn from the High Court, therefore it can be filed before the Supreme Court. Not withdrawn from the same tribunal and filed again before the same tribunal.
The real state is in my lord.
Just see, read paragraph 19. What
Last few
Yes.
lines I will read.
last few lines you have underlined it in the copy you have given us.
The petition is dismissed.
Yes. Where? Dismissed where?
Why by
Before-
the tribunal?
Before the High Court.
High Court.
In this case, the fact is it was dismissed as withdrawn under Article 226. The Supreme Court said under 32 we can still entertain it. Here there is dismissal by the same tribunal, you are going before the same tribunal. So he has rightly dismissed.
Same tribunal without consideration. Real
That is
aspect of the
irrelevant.
aspect of
That
the-
is irrelevant. You have withdrawn it. Where is the question of considering? When
But
you
question of-
withdraw, where is the question of considering?
Question of consideration
Impossible.
in the
Cannot-
case. They have filed an affidavit where they have stated that as in time come, I will consider.
We don't
it
know,
case.
we don't know.
In their affidavit.
The order is that you have withdrawn it. That order you have not challenged. So that is final and binding. There is no question of
But
reopening that order.
Withdrawn,
All right.
withdrawn lays in the logic of events because of the fact
Right,
that
we'll consider this. We'll consider this.
there were some posts.
Take down.
Petition. Item number 5.
5 to 8 are similar.
My lord, in this matter, I am appearing for the petitioner, petitioner representing the state of West Bengal. My lord, it was taken up by your lordship on 21st of November 2024. And my lord, on the basis of my learned friend's prayer, my lord, the time to file affidavit in opposition was extended. So, my lord, the last date was on 28th November 2024. But it was served on me this Monday, my lord, on 2nd of December 2024. I have prepared the reply. My lord, I need 2-3 days time, my lord, it has to be approved.
All matters you are appearing.
Yes,
5 to 8.
yes, my lord. I am appearing for the state
Situation is
petition.
same.
Same, identical issue, my lord.
Give all the 5 oppositions.
Four. 5, 6, 7, 8, my lord.
5,
Four-
6,
four
7,
writ
8.
petitions, yes. কবে ফিক্স কবে 12 12 13 12 13 13
Item number 9.
my lord, I am appearing for the respondent. I am appearing on behalf of the petitioner, my lord. The affidavit in opposition has been served upon us. Lordship, I am praying for some time to file the affidavit in reply. My lord,
When was it served?
আমাকে দিয়েছে তা নয়। Well, actually, it's in my bag. The part of it
Next
is-
week, as split matter is adjourned after 1 week.
Lord, kindly makes it, my lord. Kindly makes it 2 weeks, my lord. Kindly
You
makes
are
it-
enjoying the stay.
Then, my lord, 1 week. 1 week.
Item number 10.
My lord, in this matter, Mr. Govindu Chakraborty is appearing for the respondent number 8. My lord, due to some medical urgency, he is not present today.
Respond number
8.
is private respondent.
Yes. My lord, earlier occasion, there was a direction for filing an affidavit in opposition. It's ready with me. I'm submitting before the court. Kindly, my lord, fix after 1 week because I think
And the state respondents have, Union of India has filed an affidavit.
Yes, my lord, we have filed this application, my lord, and that affidavit in opposition on behalf of the respondent, my lord, not respondent number 8, my lord.
I'm for the 8 only.
না 8 না respondent একই জন আছে
What,
একই জন আছে
So the Union of India and others must be the applicants.
yes my lord
And only this private respondent is affidavit in opposition being filed on.
but I can pay it for your lordship.
So now there is no interim order
no interest
My lord,
after vacation.
at least my lord, so 2 weeks at 8 for
কবে কবে
Pointless. Yes,
After 2 weeks.
after vacation. Call next case.
Grateful, my lord. That. January.
Item number 11.
Position. So they need, yes, sir. They need to opposition. Tell it time. You go, Ben.
Yes.
My lord, in
There is a direction for filing affidavit.
Hmm?
There is a direction for filing affidavit. Can you extend the time for 2 weeks?
1 week.
For 10 days, 10 days.
Then it will come after the holidays. The time for filing affidavit in
Okay. Fixed on 19 December. 20.
Item number 12.
My lord, I am appearing for the petition.
twentieth.
It is expansion of ACR comments. My lord, I entered into service as a sub-inspector of police in the year 1990. I have completed
1990.
90 and got promotion in the rank of inspector of police, which is a gazetted rank, in the year 2010.
Yes.
And there was no
You
dissimilarities.
retired in 1990.
No, I have entered in service.
Oh, entered in 19.
service. And my next, the next,
You entered in 1990
as sub-inspector of
as
police.
SI,
SI.
and then you became inspector in 2010.
Yes.
And thereafter?
Thereafter, my promotion was due in the year 2019, my lord.
Yes,
In the rank of Deputy Superintendent of Police.
Yes.
That ACR comments has been made, which is not consistent with the rules framed by the police regulations. Absolutely in every column, my lord. I will place you before you. And that cost me 5 years. I have just got promotion.
ACR for which year?
17, 18. Your lordship finds the ACR comments at page 18, my lord. One officer, my lord, Superintendent of Police. My appointing authority, Inspector General of Police, my lord. My controlling officer was Superintendent of Police.
Page 18.
18, my lord. May I read, my lord? It says, the following adverse remark has been recorded by the annual conference for the period mentioned above. There is no approval by the Inspector General, my appointing authority, my lord. It says efficiency.
We don't know.
State or inefficient. Activity, inactive. Industry, hardly works. Tact, highly tactful. Temper, highly temperamental.
Judgment. You are unable to locate with the page you. (24/11/2017).
Yes, my lord. And that is absolutely sweeping comments, my lord, not prescribed by the rules. What the rules is, my lord, your lordship finds at page page 105, my lord, 105. In every column is negative, my lord. In every respect, in drop of water was not spared, my lord. I have served 27 years. Continuously, my ACR was written by my superior officers, rank of superintendent of police. There is no adverse effect to this effect.
This is by the ADG.
And the ADG has been sent, my lord, but it has been written by the superintendent of police. ADG has sent this to me. ADG sent to me for as a adverse comments, my lord.
This is the communication. Where is the ACR? This is not the ACR.
ACR is with them.
You are trying
With
to
the-
say
with the
that by
government.
one word it has been ACR evaluation has been done. That is not the case. The final assessment has been communicated to you. That does not mean it is a one word assessment. Where is the assessment?
My lord, only this letter has been assigned
So
to
what
me,
is wrong
no other
with this?
papers.
What is wrong with this?
My lord, they cannot write like this, my lord.
They have not written like this. It is not the ACR. It is only a communication to you.
Yes, my lord.
Yes, it is not. the
Let the state produce before this.
What is the rule which you say has been violated?
105, my lord. Your lordship kind of find.
Where is it?
In the petition, 105.
105.
Yes. It is just I have given the books, my lord. I have the regulations, my lord. It is. Para 77C. 77.
Which rule you are relying upon? Tell us which rule you are relying upon.
77C, Police Regulation of Bengal.
77C.
Yes.
Page 105.
105, middle order, my lord. I have the books, my lord. It says, my lord, all remarks in a confidential report or character.
Does this apply? This is what you are showing us. This does not apply to that. This is the communication made to you by the ADG. This is not the ACR. This will not apply.
But
this does not apply.
But it is remarks has been made by the superintendent of police.
Remarks.
Let the state.
What is the final remark has been communicated to you. There must be an assessment. There must be something written by the officer. This is not the cryptic. You are trying to say that the ACR evaluation is cryptic. This is not cryptic. This is not the ACR evaluation. This is a communication regarding what you have been assessed by the superintendent of police. This is not the ACR.
Let the state.
Even his lordship in the first order, if lordship kindly takes page 63 once, my lord, the entire ACR has been shown to his client advocate. Not kindly comes to page 63 once, my lord.
Page
63, lordship.
Every page has 2 page numbers. Yes.
The tribunal, my lord, kindly seen, my lord.
Yes.
Records has been inspected by the AK Niyogi, learned advocate for the applicant, and Mr. GP Banerjee, learned advocate for the state respondent. The ACR has been produced before the tribunal, my lord.
This is the order impugned.
No, this is the first order wherein, my lord, the tribunal, after considering a opportunity was given to him to make a fresh application. Accordingly, application has been made and that has also been rejected.
So where is the application?
My application is at page, my lord.
That order was challenged before the High
24, my lord. Page 24, my lord.
And on that basis, my lord, the tribunal
And
has...
where is the order passed on your representation?
Lordship. 29. As page 38, my lord, the order passed by the. And my representation each as page my lord 34, my lord.
মানে অরিজিনাল 34 এর এমনি পাতা নম্বর কত?
34 চেঞ্জ হয়ে গেছে এই যে P5 34.
Yes, I think you should file an affidavit. We think you should file an affidavit.
Matter to appear on 3 weeks.
2 weeks?
1 week. Reply.
All
Reply
right,
one
the matter to file affidavit in opposition within 2 weeks, matter to appear on 9th January. In the
Right.
meantime, it would
Yes.
be open to the petitioner to file a reply if so required.
Item number 13.
My lord, in this matter, Lord, I'm led by Mr. Bikash Niyogi, my lord. He is on his legs. Lord, I'm praying for a short Passover, my lord.
You start, let's see.
My lord, if he was present in the court, my lord, but he's on his legs, my lord.
Start, we'll come. Whatever. You start.
August 2024.
Lord, as per your lordship's last direction, there was a direction to file the supplementary affidavit annexing the earlier original application. That we have done. That may kindly be taken on.
Yes, taken on record.
That could also चाहिए. ठीक है सर, आपने प्रश्न? ठीक है.
This.
Yes, much belated payment was made. There was no disciplinary proceedings. This has been established also before the tribunal. Now, my lord, it was only an allegation, not but alleged. Nothing was proved, nothing was there on record. Therefore, there's two. Yes. Therefore, my lord, there was nothing adverse against me by which they could have deducted my salary. They paid me, but much belatedly. I went before the tribunal. I stated that, see, nothing is there pending against me. So you must give me the interest upon it. But my lord, the tribunal has come up stating that no, in the earlier prayer, there was no such direction to pay you. So we are not going to pay you. Now, my lord, we are aggrieved.
Subsequent proceedings can be filed claiming interest only.
Yes, my lord, because
that will be enlightening to us.
Because, my lord,
no, not because we are asking you what is the law. Show us, it will be enlightening for us.
That
if you come to the court seeking an arrears without interest,
no,
subsequently you can
in the
interest.
lordships may kindly takes up the supplementary which I have handed over.
Yes.
There the prayer was made. That
Still not granted. Still the situation remains that it is even worse. If you made a prayer and not granted by the court, you can't come again.
No, my lord, according to my humble understanding, my lord, if a prayer is being made, but if the courts do not go into such and
then
they
you
do
could
not
have challenge that order in the high
my lord, if they do not disallow their prayer, well, it does not constitute to be a res judicata, my lord.
All right.
But
that's why we are saying, show us the law. Let us see, it will be enlightening for us also.
Then, my lord, kindly grants me, my lord.
No, sir, this is the only issue.
My lord, that is
For
true.
what?
But then I shall be, but today I am handicapped, my lord. Honestly speaking, then I shall be coming up with certain citations, my lord, to show that this will not operate as a res judicata.
You have not shown any citation before the tribunal also.
Well, that was, that did not occasioned over there.
Why? This is the only ground on which it has been dismissed.
But the tribunal, absolutely, my lord, it went on a wrong premises, my lord.
Case.
So, my lord, according,
To appear, call him, ask him to come.
I shall, my lord. I shall intimate him,
We are
my lord.
waiting for him.
Yes.
When in the earlier round of litigation, a prayer made not considered, not granted, can you file a subsequent proceeding for the same prayer? That is the only issue we are asking the learned counsel to assist us. We don't find any. The law is very clear. If a prayer has been made and not granted by the court, then a subsequent proceeding cannot be filed for the same thing before the same court. You could have challenged it before the High Court. You did not do so. So therefore, what is the infirmity in the tribunal's order? But having said that, Mr. Mukherjee, from 2022, 10/3/22, the order was passed. And when did you pay the amount to him?
Released on 17th February 2012.
Oh, immediately is not, there is no much delay also.
According to the direction of the tribunal, salary has been issued.
No. The tribunal said to pay whenever you want. What was the direction of the tribunal in the earlier round?
Respondent to release salaries to the applicant for the months August, September, and October is written by this order. Tribunal passed order on 10 January.
No, where is the earlier order? 10/3/22 order, where is it?
Contempt করলাম page 45 page 45 এ এসে তখন ওরা দেখাচ্ছে 2022 সালে আমাকে টাকা দিচ্ছে 15 দিন page 45 স্যার page 44
Yes.
This is only in the contempt proceedings they paid me, not earlier.
Then you filed a contempt also.
Yes. Yes. In a contempt proceeding, your lordship come to page 45. In a contempt proceeding, they have come and said that they are paying money. That is of 2015 and paid it in 2022.
Even that order you did not challenge. What can be done? If you are not diligent, then nothing can be done. We cannot lay down a wrong precedent. You are not diligent enough, then what can be done? The High Court, the tribunal does not grant you interest. You don't challenge it. In contempt, the tribunal does nothing. You don't challenge it. Then how a subsequent OA can be filed?
I filed the OA in 2016. It was decided in 2022.
Maybe. We don't know.
It was decided in 2022 and they have not complied with the order. Therefore, I filed the application for contempt.
That we have seen even in contempt, the tribunal did nothing. That order you did not challenge also. That's why the tribunal has not awarded interest. Now, how can it be done in a subsequent way?
But in contempt, they said that they are paying my arrears of salaries for 3 months and they will deposit the amount in the PF. But the interest part, there is no punishment in the interest part.
Yes.
It is not that matter for my latches. I have not been paid. They have withheld my.
Heard learned counsel for the petitioner and
Sonal.
Item number 14.
Alert 14, I am for the applicant.
applicant petitioner.
Petitioner.
So the tribunal has not granted you the relief.
No, Lordship, the applicant has come before Lordship challenging a peculiar order. The tribunal hold that the respondent did not award his marks in his master degree. In spite of it, but if your Lordship kindly go through the order first. Last occasion, it was appeared before the another bench. Direction was given to file affidavit.
Till date, nothing has been filed.
Yes, you are appearing. He is not at fault. The certificate was issued to him late for his master's degree. He had passed the examination prior to the cutoff date set by the advertisement. Still, oh, you are not appearing.
Miss Sonal Sinha appearing in the matter.
Please here. Yes, you have not filed an affidavit.
Affidavit code.
Are you filing it?
No, Your Lordship, I have a report.
Not report.
Yes, I know. May I file it? Give me, allow me some time, I can do it.
Time for filing the affidavit in opposition. Obviously, they will have
Advance copy so that I can prepare.
we expect that it will be done.
So I can
Yes,
prepare the reply. Grateful, Lordship. 1 week. 12. Wow.
Item number 15.
Lordship, one prayer may I make, Lordship, before? Instead of 12, I have some difficulty.
instead of
12.
yes,
Either 11 or 13.
13.
Lordship, grateful, Lordship, grateful.
Your Lordship.
Item number 15.
I think it's right. Just wait for it. None appears for the petitioner. List after 4.
Item number 16.
Yes, for the petitioner, Lordships. In earlier occasion, Lordships. No, I have objection. Or he referred the matter only circular. That circular he has not annexed. That have circular supplied to the learned friend, and that is the circular. According to circular, he is not entitled. In spite of the senior, he is not entitled to be permission on stepping up. This is the circular. So, Opposition is there.
Stated something, I would have
You
given those.
you file an opposition in your tribunal.
You have given a copy of the circular.
Yes, yes. In an earlier date, I have circular. And the circular is against them.
Why are you shouting, sir?
That the
Don't
circular
shout,
is against them.
please
That
don't shout.
the learned friend's behavior is not so good. That I am shouting.
We don't appreciate such comments against your friend from either side. It is not in good taste by any standards and not expected from a seasoned person like you,
That is
to say the least.
what. I'm sorry for that.
We are asking you, have you given him both the circulars?
Yes, give him circular. And then circular against that.
And 29 July?
So 29, no circular.
But we have
No
recorded.
circular, no circular. This is the last circular. This is the last circular.
But last
And
day-
that circular against the learned friend. That is Amur Singh. That's kindly see the B. Kindly see the B of the circular.
B.
B.
Of which circular?
The circular dated 20th July 24. 20th July 24. That I'm giving the copy in the lordship. Having copy out.
No, last day you were
Yes, yes, lordship. Kindly see the circular.
last day you were trying to show us two circulars.
Yes, no.
20th
One,
July.
I refer the matter only one circular. He referred the matter two circular. But thereafter no circular was published. This is the last circular. And according to circular,
How we have got
student
that?
is not entitled to stepping up.
If there is no circular of 29 July,
Yes.
how did we get the date in the order?
No circular is there. Yeah, the typical error that is.
There is only one circular.
Yes, only one circular.
What do you mean typographical error?
Kindly see the circular, then thereafter.
We are not saying that there is no circular of 20th July. We are asking you, where is the other circular also? You have made us record two circulars, 20 July and 29 July. Why are you giving only one? On your submission, we have recorded you were holding both the circulars on the last day. That look, there are two
The last day
circulars.
of only circular, I rely on only one
No,
circular.
sir,
This
the
is
order
circular.
order sheet of the court
Printed
is
circular,
sacrosanct.
that I have referred the matter.
The order sheet of the court is sacrosanct. We have recorded that you are holding two copies of two circulars. Both the circular dates have been recorded.
That is no, this is the last circular there. Either no circular is there, except this. Except this.
All right.
This is a submission, can we record it, my submission?
All right. What
And
is
can
the
you see
issue?
the
What is
circular?
the issue?
This is the circular, can you see?
What is the issue?
Issue the stepping up.
Huh?
Stepping up. He is claiming the stepping up. Tribunal passed the order, stepping up in favor of the learned friend, clients, and B.L. Narayan in added respondent. And he is the stepping up, and he all along senior in earlier day, I shown the matter. All along he is senior, only one post is senior, but stepping up according to Supreme Court decision, stepping up will be counted from the appointment post, not promotional post. And his appointment is 1971, 75, and respondent is appointed in 1981. And all along, and thereafter he referred the circular. According to circular, I am reading even if the lower post revised and pre-revised, junior was drawing the more pay than the senior. Junior, that is the B.L. Narayan. He says that B.L. Narayan is junior. He is more pay than senior in virtue of advance increment granted to him, or otherwise stepping up will not be permissible.
There is a speaking order of 28 January 2020.
Stepping up. The earlier date here is seen that. That are coming, sir. Give me time. Read out now. Reason order, first the reason order. Page copy. Page 79. 71. Yes, lordship, reason order, page 71. Page 71, yes. Lordship.
71.
71, 71. This is the reason order. This is the reason order. Compliance order. Reason order কোথায়? Reason order টা দাও। না না reason order লেখা রয়েছে। দেখো না reason order। Reason order পেজ কোথায় রয়েছিল? না না পাস দ্য রিজন অর্ডার আছে তুমি অ্যানেক্সারে দেখো পাইনি এসে দেখো ইন্ডেক্সে দেখো ইন্ডেক্সে দেখো আলিয়ার ডেট হয়ে গেছে সব স্পিকিং অর্ডার দ্যাট ইজ স্পিকিং অর্ডার 20th January 22 speaking order passed by the senior division and personal officer Southeastern Railway Kharagpur 20th January 22 এটা পেজ কত বড় তাড়াতাড়ি
এটাই আছে পেজ 71
পেজ 71
এটাই আছে
স্পিকিং অর্ডার বলে লেখা আছে আলাদা বললাম আছে কিছু পড়ে তুমি আসুন thereafter come to the page 26 lordships that is the policy of the stepping up page 26 kindly see order কত আমি আগের দিন তো এখন ইন্ডেক্সে দেখো না আছে কোথায় এটা আছে স্টেবল আপ এই দিন অর্ডারটা তো এখন তর্ক না করে কাজ করে
Where is this? IREC volume 2.
Yes, lordships.
There is a reference to a rule at paragraph 9 at page 72.
Paragraph 9, page 72.
Yes. Where is this railway rule?
Paragraph 72. Paragraph 9. Yes. Page 72. Railway rule says that.
Yes, this rule. Where is this rule?
Yes, lower post in the federal.
Where is this rule? IREC volume 2. Establishment serial number 5 of 1995. Relying on this, they have rejected his claim.
Page 26, kindly see that.
Page
26. Stepping up. That is office memorandum stepping up of pay.
No, this is not the one.
And kindly see the D. Kindly see the D. The most important and relevant paragraph in this case, lordships.
No, the number does not match.
Yes, 26. Huh?
This is not the one which is referred in the speaking order.
Page
25 will continue and page
25.
25 continue.
Yes, this is it.
Continuation, that is a continuation of 26. And kindly see the relevant paragraph D. That is the relevant paragraph of this case, lordships, stepping up, in respect of stepping up. And this is the rules was published on 20th July 24. While this is the paragraph D, last. It is the most applicable and most relevant in this case. According to that, he is not entitled for stepping up. If he is senior, according to rule, it says that. That is, the rule says that. And can we see the rules? May I hand it over the rules, lordships?
Which rule?
Can we see? You
are giving one copy.
Yes, no, another copy is there. Earlier occasion, yes.
Your Lordship, this is a.
This is the rules. I am supplied that in earlier occasion.
Have to give us 2 copies.
Your Lordship, I apologize, Your Lordship, this is my mistake. I could not get it xeroxed, Your Lordship.
And you are giving a marked copy.
Your Lordship, I
Why?
just apologize.
This is the way.
I just apologize, Your Lordship.
Get 2 copies. Give us 2
Sure,
copies.
within the course of the day, I'll
This is
supply
the
the
truth.
No, no, give us unmarked 2 copies. This
This
is
is
not
the
acceptable.
second copy is there. Mark for us.
Within the course of the day, I'll supply Your Lordship, unmarked copy, Your Lordship.
Tomorrow, not today. Give us 2 legible copies. We'll see it. Not today.
And fix on Monday's lordships.
As prayed, list in the next week. Opposition. You were the applicant.
Because such statements have been made against me and I will be relying upon, I will be controverting those. People also desired.
We will not accept anything which was not on record in the tribunal. If he wants to rely, if he wants to rely or make any statement which was not before the tribunal, we will not consider it unless we give you an opportunity. That will.
I listed the number. Item number T, item number given a good project. Then earlier occasion, lordships, I have mentioned the matter one thing. Earlier occasion, court is appearing in the list on court number 11. And by mistake, court officer, the name has not been mentioned in that net. And others advocate's name is mentioned. Others advocate's name is mentioned. That is the mistake of the court officer.
We can't do anything. You know better, sir. Call the next case.
Item number 17.
Yeah, I know.
This is my writ petition. My lord, the application affidavit of service. Application for compassionate appointment had been rejected on the ground of.
You are the son or daughter?
My lord, son.
Son.
Yes.
Your father was working as?
Working as a Group D employee under the, my lord, the milk commissioner of the.
Health commissioner.
Milk commissioner under the Department of Animal Resources under the government of West Bengal.
Date of death?
Date of death, my lord, I am coming.
September 2011.
1st September 2011, my lord, the pro forma application at page 32.
So you applied when?
And my lord, I have applied on 5/11/12.
5/11/12.
5/11/12, my lord. 1st September 2011 is the date of death. I have applied after 1 year, 2 months, my lord. And that is also, my lord, there is a notification that application for compassionate appointment is can be made within 2 years from the date of death if such application had not been considered on the relevant rules applicable in the year of 2011.
Where is that? Let us.
Yes, my lord. My lord, the instant application has been considered under the 2013 rule, my lord. And my lord, the relevant provision which I am showing, my lord, that is at page 110 of my.
Now you told us that there is a provision that if an application is not considered till coming into force of this new provision, then 2 years.
Then 2
Show
years.
us that.
Yes, my lord, 110 is the date of notification, that is 1st March 2016, and the my lord relevant provision is at 111, that is clause 10 within bracket double A, new clause added to the by notification number 251 EMP dated 3rd December 2013. This is, my lord, the exceptional such cases. One, the date.
Just wait.
Belated request.
Just wait. Let us.
111. Sorry, my lord, then my lord timeline, that is 10 within bracket single A, just above that. 2 years specifically written. My lord got it? If the and the my lord, the scheme to be applied, my lord, it starts from page 113. And the relevant portion is 114. That is the eligibility.
You expect us to read this?
This is the same thing has been supplied to me.
My lord, I shall provide the type copy, my lord. Let this matter be
Wastage of time. You should have come with that. When you're relying on this, how do you expect the court to read this?
I think, I don't know.
Come with it tomorrow.
Yes.
Not today.
আমি দিয়েছি। Yes, yes, my lord. This is my mistake, my lord. I am apologize, my lord. This is before, my lord. ये लो बोलिए।
Item number 18.
I appear for Respondent Union of India. Respondent Union of India.
Respondent?
Union of India. I had to excuse me, Lord, because my clerk has missed the brief today. But I have preliminary objection as to the maintainability because
either you are appearing or you are not appearing. If you don't have the brief, come tomorrow. He will come.
Kindly.
Tomorrow he doesn't have his brief. Tomorrow.
Item number 19.
My lord.
Your Lordship, Mr. Ochinta Kumar Banerjee appears in this matter. Your Lordship, Mr. Ochinta Kumar Banerjee.
Your Lordship, Mr. Kumar Banerjee appears for the petitioner in this matter. He is currently out of station for a conference. I'm praying for not today. Your Lordship, he also appears in this matter. He's led by Mr.
HON'BLE.
Next, Your Lordship, be here.
As played. Can you come up?
Your Lordship,
In this matter, they are appearing as respondent.
For the respondent, my lord, we are for the respondent.
Yes, Your Lordship, my mistake.
He's changed places. How do we know?
In here, that is right.
Yes. You have any objection to the adjournment?
We have completed our submission. Mr. Banerjee is supposed to
So
be.
let him, that's why we said next week, come after 1 week.
Yes,
Please talk
Your
about.
Lordship, my mistake.
Yes. We have any objection to the adjournment? We have completed our submission. That's why we said next week.
Well.
Item number 20.
My lord, item number 20, I am praying for. My lord, item number 20, I am praying for not today on behalf of Munish Kumar Das. Due to his personal problem, my lord, he could not come today. My lord, only praying for not today. Grateful, man.
Item number 21.
Wait, please, your lordship. Video the service, right? The copy.
Where's your counterpart?
নাকি আগে ফাইল হয়ে গেছিল?
একটা মনে হয় দেওয়া হয়েছিল অলরেডি।
একটা দিয়ে আমি ছিলাম।
একটা দেওয়া হয়েছিল। এটা জেরক্স। Original has been given.
My lord, we have challenged two orders of the learned tribunal. The orders.
Two orders.
Yes, my lord, we have
In one way,
served,
one writ petition.
my lord, two consequent orders are there, my lord.
The second one is arising out of?
My lord.
The second one is arising out of a review.
A review and this dropping of the contempt and review, two orders, my lord.
For dropping of contempt?
Yes. My lord, lordship kindly comes to page 2 of the order dated 27/2/2024 and the order dated 26/4/2024. সার্ভিসটা থেকে দেখবে সাইড আসেনি, আগে হয়েছিল বোধহয়। হ্যাঁ, ও
Administrative tribunals. It is right there. It is there next to CPC. Get it. Next to CPC. That is it.
we have served, my lord. I don't know why they are not appearing. Lordship, Lordship is looking at the Administrative Tribunals Act.
We have that with Contempt of Courts Act.
Oh.
Contempt of Courts Act.
My lord, this act, the Administrative Lord, the Administrative Tribunals Act itself has the rules of the contempt. It's there. Contempt of court. Before the land trap.
That when the tribunal has refused to exercise jurisdiction, then appeal will lie or
oh, writ lies. That is settled, my lord, by the orders passed by the other coordinate bench, my lord. But I
Can
never
you show us. We would like to see that.
right.
We would like-
Unfortunately, I never thought of it. Otherwise, it's there because in the contempt was dropped in the land losers matter. The tribunal dropped the contempt proceeding. We came up in writ, and my Lord Justice Standen, sitting with another learned judge, asked how that is maintainable, and then ultimately he held.
Let us see it.
Then, my Lord, kindly keeps it next week, my Lord. I'll get that order also.
Monday or
not Monday, my Lord, because I have.
When do you want? Tell us.
Next Friday, my Lord. Thursday. Next Thursday.
You mean 12?
12, my Lord.
The
Item number 22.
Your Lordship, Mr. Sanjit Ghosh is appearing for the petitioner.
When the petitioner has completed this service, the respondents were supposed to make the submission.
none appears for the respondents. Just after.
Nineteenth.
Item number 23.
The applicant, my lord. My lord, I am the retired railway employee.
You are a retired railway employee.
Retired after qualifying survey of 33 years of service.
33.
33 years service. I am retired from railway service. After that, department has issued a charge sheet.
After retirement.
After retirement. And the provisional pension is paid and DCRG held by the department. The proceeding was concluded in the year of 2016. Inquiry and findings has already been completed. Thereafter, they are still retain the case and finalize the after 5 years.
They have
finalized the issue, finalized the charge sheet, disability proceeding after 5 years. And my prayer is
no. You said in 2016 they have finally concluded the issue.
Yes.
So then what happened? They found you guilty.
Found guilty. 5% minor penalty was issued. 5% cut off pension for 1 year. 15,600 only.
For 1 year. From
For 1 year.
From 16 to 17.
From 16 to 17.
Then after that they paid you everything.
No, they are detained the DCRG after 20 finalized the issue after 2021. 16 has concluded the inquiry and all findings has already been given but not finalized. Neither after retirement, neither any permission from the President of India.
When a penalty has been awarded, then what do you mean not finalized? We are unable.
Finalized for 5% cut off pension, my lord. 5% cut off pension. My lord, I am submitting the punishment order. Punishment order. Record, my lord. My lord, I am challenging the order of the CAT, my lord. Who was the one single bench administrative member passed the order without lawful mind. And he was declared there no interest will be given. Then we came to this here. Similar case has division bench of the Calcutta branch has allowed. I am retired from 2015, my lord. 15. Yes. Yes, my lord.
31/7/15.
31/7/15. Charge memo issued, my lord. Charge memo issued 27/15. The proceeding, my lord, charge memo issue, but proceeding is. And that proceeding has completed, my lord. My lord, proceeding has completed, inquiry report completed 23/2/2016. 16 proceeding has already been completed. 2016, my lord. Date, my lord, 23/2/2016. I am submitting the letter. Yes, my lord. Yes. Page 9, my lord, I am submitting the order. I will just last page, my lord. Page 9, my lord. Just I am submitting the speaker. Record, my lord. My lord, I am submitting the record, my lord. The order. Punishment order. Punishment. Put in a memorandum. Punishment order. Punishment. Really would see it.
Page 40 of the order of the learned tribunal. Page 44 of the teacher. And page 4 of the order of the learned. Middle portion. Meanwhile, disciplinary proceedings against the applicant were concluded and DRG amount was reduced in favor of such and such 14621.
Before the table. मतलब ये order is मतलब page 4 order. What is the order passed by the tribunal, my lord? मतलब page 106. मतलब order para page 5, my lord. 105 page 5, my lord.
This 83 my
that তোর মধ্যে কত করে পেজটা? My lord, my submission is only in
making submissions without fact submission and law. Nothing to find the fact there is any without waiting or anything such a casual manner by
mistake done by my clerk, my lord.
We are here to consider it fight for the sake of
Sorry.
we are required both witness.
Yes. The Supreme Court.
I have not find that, but I have got speaking order wherein they have been intimated about the order on 27/2015. No, memorandum. In pursuant to the memorandum, 750, one order was passed and that has been communicated to him, my lord, by senior DMCLA on 25/2021. Right. It is, my lord, page 31. That is one speaking order passed by department. My lord, middle court, my lord, that you are served. The paragraph is started with that you have served with the major memorandum dated such and such by senior TL just few days before your supervision from railway service, which was under proceeding. Your DCRG was withheld on account of PR proceedings, which is concluded and notice intimating person is issued on 25/2002. I find this.
As per gratuity rule, Supreme Court has passed the order. Yes, it will.
After that, Malad have requested him to give his consent for deducting that 5%. He did not give any reply. Then, my lord, we gave again one reminder to him on 1st September 2021 when he gave his consent, and immediately thereafter, that is not happening.
Yes. The inquiry report. Inquiry. Inquiry report টা দে এই তো এখানে মালাট inquiry report. Sorry, ma'am.
The order of the Honorable Tribunal also, it seeks, has been mentioned the date of the order, my lord. Page 6 of the order, running page 46, my lord, para number 7. Disciplinary case against the applicant was concluded on 25/2021. Yes.
Tribunal is recording concluded. It is recording concluded with reference to the penalty. The inquiry report must have been submitted prior thereto. So when it was submitted, he is claiming arrears. What we are required to see is whether you have delayed things or belated for which he should suffer or not. He doesn't have the necessary details. How can we consider? And straight away he is saying the Supreme Court has said, we don't know what he is trying to show us, without facts showing us the law laid down by the apex court. Which fact we will apply it on? Where is the speaking order of 3/12/21?
Speaking order is not annexed, my lord.
That is also not there. Very good. Then what can we do? Can't do anything. As trade list after 2 weeks.
$24.
My lord.
21. You are appearing in 24.
24, my lord.
Union of India, due to his viral fever could not come. Till 9th, my lord, he may not come. On 10th or my lord, any date, maybe. Fix the matter on email. Either 10th or any date.
Yes.
Till when he is not available?
Till 9, he will not be available. On 10th or any on
Today, when the matter is taken up again.
I'm appearing on behalf of the petitioner.
Your Lordship, I appeal for the. Your Lordship, this is a similar matter where Your Lordship has extended the interim order till January. The last order is not available. May I hand over the previous order wherein interim order was passed? Interim order? For the matter. I am appearing on behalf of the respondent applicant, Lordship. May I hand it over the copy, Lordship?
Teacher copy. No, these batch of matters are fixed
In January.
in the first week of January.
Have you shared a copy of this?
Just now, Lordship, I have received mine. Just now. My Lord, I don't know, my Lord, what my learned friends, Lordship, talking about which matters, Lordship. Each match.
Go through it tomorrow.
My Lord,
As
instead of
not
tomorrow,
today.
Lordship, instead of tomorrow, my Lordship, Monday, my Lord.
All right, as played Monday,
Grateful to your Lordship.
as jointly played, list on, give the date of
Grateful to your
Monday.
Lordship. Your Lordship, I have filed the affidavit of service.
Of service on taken on record.
26. 26, madam, I appeal for the petitioner, the substitution application, madam. Substitution application.
So the matter was disposed of.
My lord, substitution, my lord.
What is the matter pending now?
Substitution application, my lord.
For what? In a disposed of matter, why do you want to?
My CN 2/20, my lord, appearing in the list, my lord.
CN
2 of 201 and 21, 2 of 21 and 3 of 22. They appear in the 2 of 21, 3 of 22.
Hmm? Where is the can? Where is the can?
Can 1, can 2, can 3.
Substitution, my lord. Matter pending, man, is the petitioner succeeded in the WPST. Certain benefits were to be given. That was not paid. Contempt was filed, my lord. Against the contempt. Benefits were not given. All of us died. Petitioner.
Can 520. He's saying can 2 of 21. This can 522.
It's नहीं वो फाइल करोगे तो 2 or 3 2 of 2 of 21 and 3 of 22. 3 of 22. এই তো 2 of 22. 22.
Can
2 and 3. Can 2 and 3. Let us adjourn. From the list, it appears that can 2 of
Net GP refused to receive the notice. I have served directly to the respondent. I received, I could not annex the WPST. WPST has no bearing now. Now only contempt. They says I have no WPST because WPST was not filed by me. I filed the contempt.
whoever appears has to have the entire brief.
Only this is only a contempt.
Can we consider it without the writ court order which is there in the file? Because it is in the same file, you will have to give the entire proof.
Well, I did not appear on there, my lord. That I don't know.
So far as procedure is concerned, when each writ petition is disposed of, we shall have to return the file to the LR along with the briefs. Then when the engagement is cancelled, then if somebody files an application for contempt or otherwise, then he shall have to supply the copy of the WPST so that along with the application for contempt, so that we can take steps take instruction from the department.
Once it has been served on the respondent authorities, why should they serve again when they are filing a contempt? They will give you a contempt petition, they will give you the order which you have allegedly not complied. For everything else, your respondent will give you. They have taken the brief, they should give you. Why should the petitioner be taxed with?
Under the rules, for a LR manual, as soon as the matter is disposed of, with the copy of the server copy, we shall have to forward the entire file.
That governs you, not the court proceedings.
No, certainly not.
So therefore, if you have returned it to your respondent, ask them to give it back to you.
No, they cannot return it. They have returned to the LR office because
we don't know. We can't be guided by that. If your friend is agreeable to give you, he will give you.
Huh? Huh?
Then let it come after the vacation. In the meantime, you gather the file also.
But if my friend can permit me.
We are not going to say anything. If he is kind enough, he will give you.
No. But if you lordship permit me to appear, send that, but because permission.
We can permit you to. Mr. Mukherjee, give it. And if he will give you a
Item number 27.
I wait of the respondent. The matter of 2009.
who is for the petitioner?
They find from the backseat one Mr. Soumojit Chakraborty appeared for the petition in 2009.
What is the issue pending?
Regarding that there was a committee was constituted for give the recommended restructure to the West Bengal Secretary of Service rules. According to the order of the tribunals, you have to direct constitute a committee. 2015 committee was constituted. Then all the most 9 members was constituted. Honorable Minister in charge, Honorable Minister in charge of Higher Education, Principal Secretary Finance Department, Principal Secretary Personal Administrative Reform, Principal Secretary Public Works Department, Joint Secretary Public Substitution, Joint Secretary Administrative Training, Wanted Secretary of Westmoreland Secretary of Service Forum, Wanted Secretary in 2015.
No, but this matter is of much prior to 2000.
Parent order passed by the third.
OA 94 of 2000.
Page number
64. Page 64.
OA number 94 of 2000. Last page. 243, one can't see. 244. Last portion. Paragraph 22, want to consider the text of the document. Page 257. Direction is the function of the government to normally act on the recommendation of the state commission, change the pay scale of parity, extending effect on several other parties. Those included and forward the same for the charges, state commission looks into the member who plays there, increase one extra distinction. Similar observation the tribunal should not have mentioned the public will be because it's the amount of constitution with the authority. As you get demarcation has raised way up the respondents by the order that in the elaborate discussion stop in favor of the appropriate things to be offset by the higher forms of the construction by the discussion the space of the applicant is not sufficient. Since the order was challenged before your order passed on 26th August 2008. In the meantime, report 2019, report 2019 came into force. Since there was no stay, their government wanted to proceed with the matter. They objected because matter is pending information.
There is a stay.
No, there is no stay. Or contempt interim order was passed. The directions to constitute a committee. We have constituted a committee.
So what is the outcome of the proceedings before the committee?
In the meantime, 2015, the committee was constituted. In the 2018, when this was deliberation was going on, pay commission was constituted, and that report was published in 2019. And they have not made any demands about 2019 recommendation. Most probably they are not interested.
Okay. The chief secretary was required to pass an order.
Chief Secretary passed an order
When?
On 10th September 2015.
No,
Can you see the CAN number?
no. There is a direction on 20 July 23
Yes.
that the chief secretary will pass a reasoned order.
I shall certainly.
You go through the records, you inform us. None appears on behalf of the petitioner. Take down. None appears on behalf of the.
Certainly, but I shall have taken a copy of the order passed by
Yes.
the report. I will immediately inform the.
Yes.
Item number 28.
Well, I am for the petition. Well, I am for the petition. But this is the order of the tribunal under challenge. But what happened? The petitioner was a railway employee. The last occasion he was when the employee in the working in Noihati, the one wagon was booked. From Noihati to railway employees. Last he was appointed in the jurisdiction of the Noihati railway station. Well, the incident was took place. The one wagon was booked from Noihati to Swan instead of the wagon sent from Noihati to Gorakhpur. But that is the mistake on part of the employees involved in this proceedings. So in this proceeding has been initiated against the petitioners only. But my question putting myself, if an wagon is possible to send by the petitioner from to Noihati to again instead of Noihati to Gorakhpur, that is not possible. When the proceeding initiated, only one person, that is the petitioners. The initially suspension was suspended the petitioners, and suspension was withdrawn, and subsequently one demotion, and final enhance the punishment by removal. But subsequently thereafter the petitioners was acquittal from the charge. That has not been considered, and the disciplinary proceedings not giving the opportunity to cross examination at that time. Those the persons were involved in the said proceedings. And second thing is instead of the petitioner, the three persons were involved in the said the incidents, but only the petitioner was punished. But that is not considered by the tribunal as well as the disciplinary authority. All documents were given by the petitioner to the disciplinary authority that has not been accepted by the disciplinary authority. And punishment prescribed by the disciplinary authority had been enhanced by the appellate authority without going to the documents. That is the case of the petitioner, and acts of the respondent is totally discriminatory in nature. The incidents was took place in that point. There is so many worker, the employees are involved.
only, my lord, the allegation was raised against the petitioner, and he was, my lord, the initially suspended. Thereafter, my lord, the demotion is on post, and finally he was removed from the service. This is the laches on the part of the disciplinary authorities, but that has not been considered by the tribunal. But in the second appellate authority, my chief operation manager, my lord, without considering the, my lord, the application for appeal, my lord, they have treated as the revision. Well, I have filed my the supplementary affidavit, my annexing, my lord, the last acquittal order passed by the discharge from the criminal case by the, my lord, the appropriate court. Page 25 of the, my lord, the supplementary affidavit, my lord.
May I?
Okay.
Your Lordship, may I interrupt? Your Lordship, I'm appearing for the respondents. In this, it's a 2010 case, change in brief, Your Lordship. I was humbly praying that a matter could be adjourned for a week. Meantime, a learned friend would provide the copy of the OA at my cost, along with the supplementary affidavit. Much obliged.
Okay.
Item number 29.
Without petitioner in this matter. Well, in this matter, Mr. Tapun Mukherjee is appearing for the. I told him that this matter will be taken. He's
Not interested.
this is a case. This is a case of 2012. Well, no affidavit, non opposition has been, in spite of previous order, has been filed. Mr. Tapun Mukherjee was appointed by the last order, 30th September, to take instructions. The original dispute, relates back to 1982. Regarding fixation of gradation list. First was gradation list. That the Honorable Single Bench set aside the gradation list. They made a new gradation list and put him below the, again, this matter. Then they went up in the division bench. Division bench passed an order that was not followed. Contempt proceedings started. In contempt proceedings, my lord, at certain point, they used to present some charts as final fixation. At least 4 or 5 final fixations were done. In one of those, a sum of it was fixed as they had mentioned the application basic salary is 2070 as on 1/5/1991.
What you said gradation list then?
Yes, my lord. During this gradation list, they set aside and made a fresh, but his pay scale was not fixed properly, my lord. So at that time, my lord, at that stage, my lord, the dispute was regarding his pay scale, whether he was getting the pay scale lower to his juniors or not. So this was the main dispute, my lord. Now,
of stepping up.
No, my lord. It was not possible stepping up, my lord, because as per the rules, my lord.
Why? Otherwise, how the issue of salary will be relevant to gradation list? Gradation list is of a particular cadre for taking up a promotion.
Yes, yes.
So how the issue of salary has arisen in this process?
But in due course, my lord, when they fixed, they corrected the gradation list, my lord, there was an issue of salary, my lord. That is not now relevant, my lord. Because my lord, the issue went to whether when his juniors are getting higher pay scale, as per West Bengal service rule, he is supposed to get the same pay scale.
So therefore, a case of stepping up.
Stepping up, my lord.
Yes.
My lord, maybe. So this was the dispute at that point of time, my lord.
Yes.
So, my lord, during contempt, they gave this statement that basic salary as at rupees 2070 on 1/5/1991. They used to present charts, my lord. Now, my lord, the Honorable Court in contempt passed an order of contempt, my lord, held them guilty, my lord, and then gave certain directions to correct the order. They went up before the Honorable Supreme Court. The Honorable Supreme Court that such order cannot be passed in contempt proceeding. Again in the Honorable Supreme Court, the same statement was there. Now, my lord, the issue was my lord, the issue was rule 55 of the West Bengal Service Rules. Now, my lord, I was given the liberty to approach again, my lord.
Yes.
So on the basis of rule 55, I filed a second application before that was dismissed. I appealed again, that was dismissed, and that month I retired. Now, my lord, after retirement, I realized that my my pension was not correctly fixed. Because if I go by their own statement at that particular point of time, because that is lower than what I was actually claiming, they had fixed my salary. It was not on the basis on what my seniors are my juniors were getting. So I filed a fresh application before the learned tribunal. Learned tribunal said it is barred by res judicata because these issues have been decided. And the second issue was that I have tried to mislead the court. That was in fact partially correct. I had given an incorrect chart. Now, I will kindly remember why I was mentioning the charts. During the contempt proceeding, they used to give charts from time to time. So this statement recorded in the two judgments of the court on the division bench as well as that basic salary of rupees 2070 as on 1/5/1991. I am now claiming only on that basis, no other basis, my lord.
1/5/1991.
My lord.
Basic salary.
My lord. 2070.
So because this was a wrong statement.
No, I am saying even if you have made this statement, I did not make that statement. You made that statement, pay me that because it is lower than what I was claiming. What I was originally claiming that I did not get. But since subsequently the court has held otherwise, that rule 55 is not applicable to me. So now, my lord, I am paying. Even this amount which was admitted by them during the proceedings is not been given to me. My fixation has been done much below that. My case is solely on their statement and nothing else, my lord. That you have made the statement before the Honorable Court. Your lordship will kindly see page 82, my lord. Page 82, this is Honorable Supreme Court judgment. I will also show from the division bench judgment. Page 82, the Supreme Court, this is a reported judgment, my lord. Page 83, paragraph 9. subclause 4. The basic pay of respondent as on May 1, 19 was fixed at 2070, whereas Roy, who was junior to, was drawing basic pay of 2135. So my claim for 2135 has been refused by the Honorable Court. I have not appealed against that.
The order which is impugned here, let us come to the order, which is the impugned order. We are not concerned with that history.
No. This is important because the
Impugned order is 6/3/2012.
Yes.
A very limited scope of that proceeding.
Yes.
An order passed in a miscellaneous application.
That is the second order, matter.
Huh?
That is the second order, matter.
Oh, this
Order passed by the High Court.
This is the order impugned here.
Yeah.
What do you mean second order?
Matter, there is a no.
Let us see your prayer in the writ petition.
Seven, 17 September 2010. এটা কোনটা? না নিশ্চয়ই করবো। No, it is annexed at এই তো page 180 17 September 2010 page 180 my lord. Well, subsequently the honorable I challenged my lord. The honorable High Court has, since there is an allegation against you, then I again went back my lord in a miscellaneous application. The court clarified, then I have filed this my lord. The original order is this one my lord. এইটাকেই চ্যালেঞ্জ
application for MA application.
MA application কেন সেটা নিয়ে কি হবে?
Set page 180.
180 order passed by the tribunal.
180 starts from 180.
2017 order. 2010 order.
2010 order. But it,
Seventeen 9/2010.
my lord.
17/9.
17/9/2010. 17th September 2010.
The 180 to tribunal order. তারপর অসীম ম্যানেজার অর্ডার দিল। মিলছে না কেন?
So what is your grievance now?
My grievance is that you had admitted during the proceeding, I have failed in all my claims. Higher pay scale, I have failed. Now, during the proceeding, you have yourself admitted that a particular pay scale has to be fixed on
that admission.
My lord, kindly see page 82, the Honorable Supreme Court judgment is there, and also I am showing this Honorable.
So where is the admission? Show us the admission. You are relying upon an admission.
But that admission has been recorded in the judgment, my lord.
In which judgment?
In the before the Supreme Court, also before the Honorable High Court, my lord.
Where is that? Show us.
My lord, that is at page 82. The judgment starts at page 82. As kindly see page 83, paragraph 9, subpara 4.
This is your grievance. This is not a. This is taking note of your grievance. This is not an admission.
No.
No, contempt proceeding, they were there.
Respondent in the contempt proceeding.
Respondent was, I was the respondent. He should have been remained.
So this is your stand in the contempt.
Yes.
Yes.
The basic pay of respondent as on May 19 was fixed as at 2070.
This is your submission. This is not an admission. You said there is an admission. Where is that admission?
My lord,
unless you show the admission.
Notes দেখো না কোথায় ছিল এইটাই page 75 page 70 page 75 my lord starts from 71. This the honorable court is recording the facts, my lord. Even on the basis of the final calculation, this was for perhaps the fifth final calculation, my lord. Even on the basis of the final calculation, which was
75.
75, my lord, bottom.
Page 40 of the internal page 40.
40, my lord, page internal page 40. Absolutely last few lines, my lord. Even on the basis of the final calculation which was submitted on the last date of hearing by respondent authorities, we find that the respondent have not fixed the petitioner's basic pay correctly and have thereby
failed to confer the consequential benefits of the according to the final calculation. Kindly see, my lord. Kindly see.
These are your submissions.
No, this is they were submitting. Kindly see page 75. They have been giving charts. I have not been submitting charts, my lord. Kindly see paragraph page no, page 34, my lord, internal page 34.
Please come to page 74.
74, my lord.
Page 39 of the order.
My lord.
Second paragraph. The petitioner has submitted. From there, your submission start. They continue till the next page. This is your submission being recorded by the High Court. This is not an admission. It continues to page 76, the petitioner's submission that the respondent. So it is continuous submission of the petitioner. That cannot be taken to be a admission by anybody.
এই যে অর্ডার রেখেছে তো সবন করে গেল তো জানা করে that order has been set aside by the Supreme Court.
No, that I am not disputing, my lord.
Yes, sir. There is no admission.
Yes, my
Attempt was held against the Chief Secretary and 5 charges by the Contempt Court, by the Division Bench Court. Chief Secretary was found to be guilty of Contempt Court. Then, Chief Secretary went to the Supreme Court. Supreme Court set aside the order, and he has given liberty to approach the appropriate forum in accordance with the.
So therefore, he says, I have approached. Now I am only relying on an admission.
No, he has not filed original application. He filed on one miscellaneous application for clarification of the order.
Whatever it is.
That is another issue, my lord. That was only on the issue High Court said when I approached it.
You say that having lost everything, I am entitled to basic pay of
Yes,
2070 with effect from 1/5/1991 based on an admission.
What?
Just show the admission. That's all.
My lord, my lord.
এটা তো হয়েছে এমএতে নাম্বার এমএতে কি করে হয় রিভিউ করতে issue judicata because of Supreme Court order.
Well, I am a little confused whether this is the because petitioner is submitting, my lord, from as your lordship has page 39, second paragraph. I want to place that only if this paragraph is a, because from the next, no doubt there was these are court's observation. Kindly, I'll be. Hmm. Yes, my lord. We should- That is different, my lord. No, no. When the order is set aside before the division, but division says you have you go below the melon. My contention was your lordship will kindly see. This is the division bench.
Yes, it will go to the Supreme Court.
I was actually contradicting the finding of res judicata. Res judicata, when a dispute is on an absolutely different basis, my lord, the basis was different during that proceeding. If I am right, my lord, that a certain observation is made by the court. But there is a recording of a certain fact, my lord. I'm not saying. Because on page 30, yes. Here, my lord, because my lord, if your lordship goes through the history, I have repeatedly been subjected to the same thing. Court is passing an order. I have been given something which. Yes, yes, yes. My lord. That is, I can, at least if this is the only part, this is the only part. Your lordship can fourth page 36. This final calculation chart was court has recorded has been submitted. At least, my lord, that at least, my lord, they can say if this was indeed their statement. Now, if they come, they have not even filed an affidavit in opposition. Because on the point of res judicata, my lord, I will, my lord, argue, my lord, that this will not be barred by. Eh? After lunch, so, my lord, then my lord, can you keep it tomorrow or some other day? I will, because I. Tomorrow.
Yes.
Item number 30.
Sir, Torunjoti Tiwari is appearing for the Union of India. I'm praying for not this week.
None appears for the petitioner list after the
Item number 31.
My Lord, I am for the petition and this. My Lord,
yes.
the petitioners applied for the vacancies of liftman. And in the trial court, my Lord, the respondent submitted that that panel is no more there. Therefore, the application will not be considered. The Lordship would kindly come to the operative part of the judgment, that is at page 63. Second paragraph, my Lord.
10th January 2013 order.
Yes, my Lord. Yes, my Lord. Thus, from the submission of the petitioner, as well as from the respondent,
There is some can pending.
can is, my Lord, disposed of by my Lord Justice Topoproto bench. That was restoration restoration was restored. Their lordship directed that it will come up for the final hearing.
By which order it was disposed of? Can 4?
My Lord, that was disposed of.
We don't find any such order.
That was disposed of, my Lord, on 3rd October 24. I don't know why it has not gone down there. My brief endorsement is here. 3rd October 24. The other side was there, present. That was, my lord, the restoration of the restoration application. There were two restoration. My lord, my endorsement is on 3rd of October 24. The lordship directed restoration, don't bother, I will hear the main matter after 1 week after the vacation. The final hearing. I don't know why it has not gone down there.
But you said it has been disposed of, so that is not the situation. The lordships may have said that we will hear it the main matter, but that does not mean IF4 has been disposed of.
Yes, my lord. Then your lordship kindly dispose it of.
You are saying it has been disposed of. We are looking for an order. You are telling us an order. There is no order of October 24. We don't find any order of October 24.
The matter appeared, my lord, and I appeared before their lordships. It
We
appeared in
asked-
the list. It was in the list.
Giving an incorrect fact, there is no disposal. Now you are telling us that it was not disposed of. Earlier you said it has been disposed of. It
Hello,
has
it
not
has
been disposed of.
not disposed. Yes, ma'am. Don't find, my lord.
You have appeared, then still you are giving us an incorrect fact. It is surprising. At least tell us correctly what happened, then we'll consider. If you say things like that, we have to check every detail when you argue. We don't know how to go about it.
I don't know why it has not gone down there, my lord, but I appeared on that occasion. That's why there is endorsement in my brief. 3rd of October. It's not gone down there.
After that, again it has been listed. On 13 November 24, the can was again listed. On which date you have not appeared? How do you say that it has been disposed of?
Can is, my lord, regarding restoration application.
No, can is restoration of restoration.
Yes, my lord. Yes, my lord.
It's not a restoration application.
Restoration of restoration. That's true, my lord. It was on my personal ground, my lord, that I could not appear on those occasions.
Who was earlier appearing for the state? Serve a copy on the state council.
Yes, ma'am.
Earlier, anybody was appearing?
Yes, Master. Subir Pal was appearing and he appeared on that day also.
We don't find one appears for the party.
I can serve him again.
Support of the application.
Mr. Subir Pal was appearing.
One appears to be- No, on all the dates, there is no representation. There is only one date, 26/2/14, when you have moved an application for early hearing, it seems.
Yes, ma'am.
On that day also, there was no counsel for the respondent.
I'll serve them, my lord.
After that, on none of the dates, oh yes. How to ensure their appearance? You serve a copy on the state council.
Yes, my lord.
Let a copy of the in
My lord, in December, my lord, I'm going out of state and let it come up in January list. My lord.
on 11th next week, on Wednesday itself.
No, my lord, I'm leaving on this Saturday. Kindly make it in January.
Then strike off that order. Learned counsel for the
January list. I'm grateful.
Item number 32.
What punishment was awarded?
2 increments was allowed.
Withheld.
Without any future effect.
Non-cumulative or cumulative?
Non-cumulative.
Just those minutes. Then restoration. Restoration, no reply file.
None appears for the petitioner in presence of respondent.
Item number 33. Item number 34.
My lord, the petitioner advocate, Mr. Shamimul Bari, who is the advocate on record, he is engaged in quotum number 25. I'm praying for not this week.
Lordship, I'm being led by Advocate Abhishek Prasad, Lordship. He is currently engaged in court 35, Lordship. Lordship, I'm not in the panel, Lordship.
My lord, I'm praying for not this week, my lord.
Item number 35.
Mr.
Yes,
is appearing.
yes, but for the petitioners.
My lord, Mr.
Um,
is appearing for 1-2, respondent number 124. Can you make it not today? My lord, due to some personal difficulty, he is not available in court today.
All
Can you
right.
make it?
Personal difficulties. All right. Not today.
Item number 36.
None appears for the petitioner.
Item number 37.
To clean. To clean the next file. The adjournment of this matter. None appears.
Item number 38.
Argument, I am for the petitioner, my lord. I have taken verbal instruction from the clients, my lord. They doesn't want to proceed with the matter any further, but I beseech your lordship to kindly keep the matter on Monday so that I can file the written instruction, my lord.
Submitted by the learned.
Item number 39.
Your Lordship, I am appearing for the respondent. Union of India. My lord, today I missed the brief, my lord. This is the difficult.
Let's see. Nobody is here for
Yes.
the.
Your Lordship, as it appears from the earlier order that affidavit in opposition has been filed by us and time was sought out for filing affidavit in reply by the petition.
On 4/9/2018.
No, the last order, my lord, subject to correction is on the 23rd of February 21.
Yes.
So if your Lordship direct, my lord, I can serve a notice upon the learned lawyer who is appearing for the petition and your Lordship may fix a date.
No, but somebody is already appearing. Why notice has to go? He should have been here.
My lord,
Matter is on the list.
my lord, that is true, but my lord,
In all the old matters, we are fine. Barring a few, nobody is appearing.
but if they appear,
This appears to be arising out of a selection process.
Yes.
He was a OBC candidate. He obtained age relaxation.
Yes.
He was given age relaxation. He was much below the last person selected.
Yes. So he is not coming under the zone of
Consideration. Yes, that's what we could gather from glancing through the file.
Yes. My lord, matter can be as because my lord, I have the occasion to appear before your Lordship in other matters. Your Lordship is disposing all the matters. So my lord, it can be disposed if your Lordship fix a date. Because in this matter also I am led by Mr. D.N. Roy, my lord, who now becomes a senior advocate. So I can also, my lord, intimate Mr. Roy so that he can argue on behalf of union.
Mr. So-and-so appearing on behalf of the
Item number 40.
Same transaction. Let the matter be listed after vacation.
Item number 41.
Your Lordship, I am appearing for the appellant. My Lord, I recollect, my Lord, on the last time it was dismissed for default and restored by the coordinate bench. If your Lordship kindly fix any date, my Lord, convenient to your Lordship so that I can argue.
Union of India is
Union of India is the appellant, my Lord.
Yes, it was restored on 13th of January 23. Find the implement. How to find the implement?
এটা তো restoration তারা justified or this are there.
So file has to be arranged.
Item number 42.
None appears. The petition is dismissed.
Item number 43.
My lord, I beg to appear on behalf of the petitioner, my lord, in this matter.
Yes.
My lord. Impugned order at page 98, my lord.
20 June.
Yes, my lord, 2018.
Yes.
In the impugned order, my lord,
You were appointed on a temporary basis as Tehsildar. Then what happened?
then subsequently she was regularized,
Where is that order of regularization?
my lord.
Where is the order of regularization?
Order of regularization. My lord, at page 25. First, my lord, may I humbly submit, my lord. Kindly see annexure T1.
Just give us. Yes, what are the document you're trying?
Annexure P1.
Annexure?
P1. My lord,
P1.
at page 23.
2 pages before this.
My lord. My lord, medical examination. District Land and Land Reforms Officer Birbhum, my lord, requested the Chief Medical Officer of Health, Birbhum District Hospital, for medical examination of
Petitioner
of the petitioner for the purpose of appointment, for giving appointment.
No, but that is of 2000.
2000. So my case is that my medical examination was held, but prior to my lord, I have to then my lord submit from, there is checkered history in this case.
No, just we'll hear you. We just first thing is that when were you appointed on temporary basis?
1975.
1975. So you say somewhere around 2000 the process for absorption started.
No, my lord. What has happened? These Tehsil Mahurars filed application before the Honorable High Court. Honorable High Court was pleased to give appointment to them in a phased manner. When appointment was not given, these temporary Tehsil Mahurars filed original application, which was, my lord, OA number 1701 1997.
OA number?
1701 of 1997.
No, this prior to this you said some writ petition was filed.
First writ petition was filed.
So writ petition there was a direction, then why did you go to the tribunal?
Because when tribunal, when we filed the application, my lord, in the year 1990, CO number 7964W of 1990. At that time, tribunal was not there. Tribunal.
That we have understood. That you need not tell us. That much we know. What we are saying is that when you say that the writ court had already issued a direction, then why did you go to the tribunal?
Appointment was not given.
So you should have filed a contempt. You should have filed a contempt.
My lord, at that time, that was not done.
So where is the direction passed by the High Court?
High Court, my lord, that order is not with me, my lord. At paragraph 3, my lord, I have stated.
What is the writ petition number?
CO number 7964W of 1990.
In a phased manner.
Huh?
In a phased manner.
In a phased manner.
No, but where is that order?
Order is not, my lord, here, my lord.
All right, then what did the tribunal do?
Tribunal, my lord, disposed of the application by order dated 1st January 1999, directing the government to give appointment to the applicant.
Where is that order?
Yes, my lord. Page 70, my lord.
Page 70 is the order of the tribunal.
Tribunal.
Not the High Court.
No, tribunal. At page 74, my lord. 5th paragraph. Just one from bottom. Your party portion. Second last paragraph, my lord. Internal page 5. At page 74 of the writ petition.
Yes, then
My lord, in compliance with with the order of the tribunal, the government decided to give appointment to the Tehsil Mahoras. Accordingly, medical examination, my lord, order was passed on 1st January 1999, and medical examination was held on 27/3/2000. Police verification also held on 27/3/2000. After about 1 year, 3 months,
yes,
my lord. Then, my lord, appointment letter was issued. My lord, finally annexed P2, my lord, page 25. Relevant page 26.
why 26 is the relevant page?
Relevant page is the name of the petitioner is there.
Yes,
My lord, the petitioner joined the service to the post of Group D, my lord, on 21st June 2007. Page 28.
Page 81.
No, page 28. I hereby report to my duties as peon, BLR and BLR.
yes,
My lord, the petitioner could discharge service, my lord, satisfactory qualifying service for 8 years, 2 months, 10 days. And as a result whereof, she fell short of 1 year, 9 months, 20 days in the 10 years pensionable service for which she is not granted pension. In my case is that the learned tribunal
so
dismissed.
you retired somewhere in 15.
2015.
2015.
What is the
31st
date?
August 2015.
31st August
2015.
Yes,
So, my lord, may I submit my case is that my right to appointment was crystallized much before when the Honorable Tribunal, Learned Tribunal passed order on 1st January 1999. So there is, for the lesser negligence of the respondent authorities, the petitioner was giving appointment after causing more than 7 years delay, for which the petitioner should not be penalized and the delay should not be attributed to the petitioner. And the government cannot take benefit of its own wrong by refusing pension. If I would have been appointed after the order passed by the learned tribunal, I would have got and reaped more benefits, service benefits also. But government deprived in both ways.
You filed a contempt when they were not complying with OA 1701 of 97. Did you file a contempt?
Yes, my lord, in contempt.
Where is the order passed?
My lord, page 94. As the government complied by giving appointments, so contempt proceeding was dropped. The learned tribunal, my lord, dismissed the application of the petitioner on the basis of the judgment passed in the case of Krishna Das Gupta. So that observation has been dealt with by another division bench presided comprising the Honorable Justice Dipango Datta and Honorable Justice Saugata Bhattacharya. My lord, may I hand over the judgment, my lord? 19 SCC online, Calcutta 9103 and 19.
2019?
SCC online. Paragraph 6 and 7.
910.
Division bench. My lord, paragraph 6. May I read, my lord? Mr. Dotto, learned additional government pleader appearing for the respondents, has, however, referred to and relied on the decisions of coordinate benches of this court in WPST 11 of 2011, Krishna Das Gupta versus State of West Bengal, and WPST 324 of 2012, or Kumar Sarkar versus State of West Bengal, which were relied on by the tribunal to spurn the challenge, and has contended that the petition deserves in limine dismissal based on such decision. And this case also of Tehsil Mohra, similar and identical issue. Similar employee, same employee, her case, his case was rejected. Paragraph 7, my lord. We have perused the decisions and find that law has been laid down therein to the effect that there cannot be retrospective appointment. We have failed to comprehend as to how such decisions could be of any assistance for the respondents to successfully urge the tribunal to dismiss the original application. The petitioner has never claimed service benefits from any date prior to his appointment on 20th June 2007. Instead, what he claims is that he should have been appointed immediately after examination of his medical fitness and verification of antecedents were over. And since the delay in issuing appointment in his favor is not attributable to him, he does not claim any service benefit, but only claims condonation of the deficient period of service to be entitled to pension and other retirement benefits. The tribunal evidently omitted to consider the petitioner's claim in the proper perspective. We are thus of the opinion that the tribunal proceeded to dismiss the original application of the petitioner based on misapplication of the ratio of the unreported decisions of this court. And in my case also, my lord, my case was dismissed by the tribunal, my lord, relying on the decision of Krishna Dasgupta. Hmm.
Yes.
On similar issue, my lord, on the point of delay in giving appointment, the division bench presided over by the Honorable Justice Dipankar Datta and Honorable Justice Pratik Prakash Banerjee also passed judgment. এটা রিপোর্ট হয়েছে কিন্তু আমি জানি না রিপোর্টেড হয়েছে শুনেছি আনরিপোর্টেড হ্যাঁ 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 না আচ্ছা আচ্ছা হ্যাঁ হ্যাঁ এটা এটা
What is the date of the order passed in the contempt proceedings?
My lord. June
No,
2001.
no, how is that?
One.
No. Can you see page 94, left hand side?
Yes, can't see, we can't make out.
That's very difficult to reach.
2004. 26/3/2004.
26/3.
No, 20. 20th March.
20 June.
Yes, 20th March, my lord.
20th March 2004.
2004. On the threat of contempt, my lord, the government was compelled to give appointment. Though the right to appointment of the petitioner was crystallized when the, my lord, order was passed by the ones in the by the Honorable High Court.
But that order you are not showing us.
Yes, ma'am. So, my lord, I am not relying on that.
No, but we have to rely on that because the tribunal has said to comply with the High Court's order.
Yes, my lord.
The tribunal's order cannot be complied in isolation.
Yes, ma'am. So, my lord,
it has only said that we are bound by judicial discipline. High Court has said to implement a particular scheme, you implement it. Now that scheme is subject to availability of vacancies. At least until 2004, vacancy was not available for you.
My lord.
Which is apparent from the contempt proceedings.
My lord.
That 7 have been offered, 7 have yet not been offered.
Vacancy means, my lord, actually, there was vacancy.
Please read the contempt order, sir.
Yes, my lord. And
so 7 vacancies were existing, 7 people were offered. Out of 20, 14 were found eligible, 7 were offered in 2004. Regarding the remaining persons, they said before the contempt proceedings that we will follow it as and when it can be done. 3 years after that, you have got it. Where is the delay? And that is why the judgment that you are relying upon, read paragraph 10 of that judgment.
May I read, my lord?
Yes, please read.
We see no reason not to follow such decision and make similar directions. After all, it is a matter of factual determination as to whether the examination of medical fitness and verification of antecedents of the petitioner were completed in 2000 or not, as claimed by him. If indeed that be so, it would require further assessment as to whether there were adequate vacancies for accommodating the
Only
petitioner.
after seeing all this, we can arrive at a conclusion. Only then a court can arrive at a conclusion that there is delay or misdeed on their part, and if there is a misdeed on their part, they may be directed. So that is the division bench. Subsequent division is same as the earlier division. There is no difference.
Yes, my lord. But
Yes.
but in any way, my lord, I have been
But
deprived.
you show us that they have delayed. Until 2004, we don't find any delay. So after 2004, what happened?
After 2004, they have given me appointment on
2007, 20th of June 2007.
21st June
So
27.
these 3 years, there is
Yes,
a
my lord.
question
I
of
have
3 years.
I fell short of my lord 1 year, 9 months, 20 days.
That is not the point, sir. It cannot be given just. It is unfortunate that we are seeing.
My lord.
But we have to go by the rules and the law.
Definitely, my lord.
So you
My lord.
are claiming a appointment by way of absorption or regularization.
My lord.
Under order of a high court,
My lord.
which says it can be done only in a phased
May
manner.
I rely on some other citations, my lord?
Show us the order of the high court. How can we proceed to consider that there is any lapse on their behalf?
Yes, my lord. Now,
unless we know what is the direction.
Other division bench, my lord, in some other cases, held that
Show us the
when
judgments.
the order, yes, my lord, I am giving the
We'll consider everything, but then
my lord. Ashwin Kumar Chakraborty, in this case, my lord, Honorable High Court was pleased to direct the government to condone more than 2 years shortfall on the ground that when their right to appointment was crystallized by an order of the court.
So you come back to the same thing. When did your right to appointment crystallize? When the vacancy occurred in the last phase when you were appointed. After the vacancy occurred, how much delay is there? Where is the pleading
my
for
lord,
this?
vacancy, my lord, there was vacancy, my lord.
We don't know.
My lord,
we don't know. We can't say. From the order passed in contempt, it appears otherwise.
In reply, their statement is that
you have annexed, you are relying upon it. You cannot say anything contrary to this order.
So, my lord, in this case, that is the, my lord, dealing with the judgment of Krishna Das Gupta, on the basis of which the tribunal dismissed my application. In the judgment of Ashwin Kumar Chakraborty, my lord, passed by the Honorable Division Bench, comprising the Honorable Justice Dibankar Datta and Pratik Prakash Banerjee. My lord, in this case,
we are not saying that it cannot be done. You have to lay the factual foundation for such direction.
So, my lord, I have to
issued by the court. Where is the factual foundation? We are asking you. You are giving
I have to submit.
You are
So,
giving
my lord,
judgment after judgment.
Kindly allow me, my lord, some time to submit the copy of the order passed in CO number 7964.
Yes.
Of 1990.
But not only that. First, we have to see what was the direction, because the tribunal's order is only to comply with the High Court's order. It has not given any independent order.
To give appointment in a phased manner.
We don't know. It's not before us.
So, my lord, kindly give us, allow us some time.
That is one aspect of the matter, and then another aspect of the matter is the West Bengal circular dated 15/10/98.
My lord.
Both these things, the CAT has said that it has to be complied, the state administrative tribunal. So where are both these things? Where is the circular of 15/10/98? Please see page 75.
On 57 of 1990.
My lord, 15/10/1998.
Is this part of the record?
My lord, kindly allow
me. The things are not there. How can we?
Sorry, my lord, I beg to be excused, my lord. Kindly allow me some time to.
1 week.
My lord.
As paid by petitioner's counsel.
Well, I'm grateful, man. Much obliged, man.
Item number 44.
Lordship, I'm for the petitioner. Advocate Sabita Roy is not present today. She's suffering for her health issues. I'm praying for 1 week adjournment, Lordship.
As prayed. This after 1 week.
Forty-five.
45.
Extra fives. Item number 45.
On a list on, give the item number 46, 47.
My lord, I beg pardon. My lord, regarding item number 46, WPCT number 131, I pray before your lordships on behalf of my senior Mr. Ajay Devnath is appearing in this matter, but his uncle has died. Tomorrow will be complete. All the rituals, the death rituals will be completed tomorrow, my lord. I pray for.
On account of a demise in the family of the learned. For the respondent. My lord, the petitioner was originally appointed by the railway at Asansol division, my lord. And subsequently, my lord, there is a requirement and he was transferred to Jamalpur in Irmi. Irmi is my lord, institution of, my lord, 1 minute.
in Indian Institute of Mechanical and Electrical Engineering. He was transferred to that post, and that was and technician, TV technician, mechanic technician, group 3. My lord, subsequently it was for 4 years, and it may be extended for 6 years. But they are supposed to inform the department, and he may be transferred to back to Asansol post, Asansol in his original parent post, parent cadre post. But he did not apply. Somehow, he has required to inform the department after the lapse of 4 years or 6 years. My lord, it is my lord. I mean, it is in his letter, my lord.
You are saying that duty was cast upon the employee to intimate the employer that my tenure has lapsed.
Yes.
Where is this rule, regulation, circular, or where is the direction which mandates such an obligation on the employee?
Yes. Retention, his retention letter is, my lord, at page 71. He is paid for retention, and where it is required, let me check. It is, my lord, if my lord come to page 40A and 40B. It's 40 is the original notification. It is in Hindi. So, my lord, it was translated in English at 40 and 40B, my lord.
Yes, there is an obligation cast.
Such obligation. And in pursuant to that, my lord, he wrote a letter that he was requesting for retention.
So he wanted to be at that place only.
At that place, at this post, my lord.
Which
Now,
you accepted.
For on the compensate ground, we have
Whatever ground, it was accepted.
for the time being. My lord.
Yes. Where is that acceptance?
There is no such acceptance, but he is there. My lord, there is no official.
So he discharged his obligation by writing to you. But he said, I don't want to come back.
Yes. Yes, my lord, he is there. My lord, subsequently, since my lord, kindly come to page 28A, my lord, kindly once. Page 28A, my lord.
Page 28.
28A, my lord. Once, why I'm telling you, because he was originally transferred from Asansol on lien basis. That is the letter.
That is immaterial.
No, only my lord, I
Now
want to,
that is not of any relevance.
no, my lord, only want to show that he has transferred to on lien basis.
Yes.
Now, my lord, there is requirement at IRMI is no more. So he was required to send to the original position, original division, original post.
So his lien was retained in which organization, which place?
IRMI, my lord, IRMI, IRIMI, IRMI. Now there, that my lord, requirement is not there. The system has been changed. No TV and all these things. There is some another system in now has been taken by that department. So his requirement at there is no more. So he has asked to go to his original post. But he said, my lord, then no, I have the qualification, etc. I have to get a higher post, grade A post as a network operator, etc. So, my lord, that post is not available with that IRMI. So how can they give that post? Besides that, my lord, what post and pay scale he is asking for, it is for UPSC promoted cadre, grade 1.
What was his prayer before the tribunal?
Yes, my lord, it is, my lord. I'll show you, it is there. At page, my lord, 59. Network administrator.
You have designated him as network administrator.
There is no such post, my lord.
But you have designated him as such.
No, never. Not a piece of paper, my lord, there. We never designated. It's mechanical, my lord. TV mechanical, TV mechanics. TV technician, actually. It's page 39, my lord. It is TV technician, ex-cadre. So the post is asking, we have no scope, my lord. There is no such post. Besides that, grade A post has to be come through UPSC, my lord. No, it is there since there is a stay order, my lord. I have filed a vacating application as well, but it is pending since then. It is there, yes. I have filed, my lord, on 7/12. Just a minute, my lord. 9th day of January 2020. Yes. Matter is now taken up, so it is there. And he is working there. In fact, he has no work, my lord, as such. So he is sitting idle and getting payment, getting his salary. Yes, my lord, interim order was passed. Interim order was passed. Yes, my lord, I don't have.
Yes, please. Yes.
Deferment to right. That time my lord, mid period, so that's a very difficult situation.
They will check. You have filed it.
Yes, my lord, it is original slip is there.
All right, then they will find it.
Item number 49.
Lordship, in item number 49, Lordship, I'm saying for not this week, Lordship. Kindly
Why?
take up the matter on Monday. Lordship, Daniel advocate was present before the court today also, Lordship, but he received some phone call from home, Lordship, some medical urgency.
This is the second adjournment that you are taking in this matter.
Lord, in this matter, my lord,
Petitioner.
Mr. Honorable Mitra is appearing on behalf of the respondent of 5 matters. Clear. But my lord, the answering respondent is my lord, the railway, my lord, Southeastern Railway.
My lord, I am for the Southeastern Railway. My lord, kindly keep it on Monday, my lord.
Monday.
Kindly keep it on Monday. At any time, my lord, kindly keep it on Monday. Why
My
the
lord,
CBI is a part?
My lord, there was a my lord query that in which my lord, on that occasion, Mr. Mitra has filed a my lord, an intimation from the CBI, my lord. So we have advanced our argument. So now the answering respondent is my lord, the railway authority, my lord, Southeastern Railway.
My lord, I have to take some necessary instructions, my lord. Kindly keep it on Monday. Why are you taking repeated adjournments? We are not going to adjourn this matter. You argue. What is it? Last day also it was adjourned. The old matters are just to be kept pending. Please proceed. This is not the way.
Lordship, kindly fix the matter
Casual
on Monday,
adjournments we
Lordship.
don't appreciate. If you have a cause for adjournment, we are not adverse to it, but casual adjournment we don't appreciate. What is the order? Let us see the tribunal's order. Who is the main contesting respondent?
Railways matter.
Come that side. Come that side. Why are you? Respondent is standing in the place. What is the order? Let us see the order. Some ACR entry, adverse entries in the ACR. So the assistant commercial manager. How the delay has been accepted? How your delay has been accepted?
But actually, my lord, I don't have the brief today also. My lord, kindly give me 2 days time, my lord. Kindly give it Monday. I shall answer your
Not
lordship
today,
separately.
not today. Come tomorrow.
My lord, kindly give it Monday, my lord.
No, sir. Come tomorrow, not today.
Item number 50.
No, I am for the petitioner, my lord. My lord. Matter was appeared very last 4 occasions. No one was appeared on behalf of the private respondent. For this reason, this honorable court directed me to serve the copy upon the learned advocate who appeared before the tribunal as well as the petitioner again, my lord. That I have served, my lord. My lord, the matter is related to the pay fixation of the private respondent. My lord, the herein, the applicant before the tribunal was working as a loco pilot. And my lord, while he was working as a loco pilot, due to his health problem, my lord, he was decategorized. And my lord, he was from the loco pilot and he was, my lord, posted as a head clerk, my lord. And that was held in the year of 2008. And subsequently, my lord, in 2014,
Was working on which post?
initially loco pilot.
Yes.
My lord, that is the train driver, my lord, electric train driver. And my lord, due to his visual problem, my lord, he was decategorized from the loco pilot and he was, my lord, posted as a head clerk. And that was held in the year of 2008. Subsequently, my lord, in the year of 2014, he told that one of his, one Sigul Pandit, who was working as a loco pilot, his pay was refixed. So my pay was also refixed.
You are filing a writ petition against the direction to reconsider.
No, my lord.
Yes. What is the direction of the tribunal?
Direction of the tribunal.
Please read
Yes,
the
yes.
direction.
My lord, kindly see the last
Yes.
paragraph.
Yes.
Page 5, paragraph 5. Since it is not disputed by the respondents that the applicant is identically circumstanced to the Sigul Pandit and having noted that representation to the applicant is pending since 2014 and no complicated question of law needed to be decided, I disposed of the way with the direction upon the senior DPO and or any other competent authority to consider the representation.
Yes.
And grant the appropriate benefit to the applicant on par with the Sigul Pandit.
So when you admit that they are both identical,
No,
then
my lord. For this reason, earlier occasion, this honorable court directed me to file an affidavit. Why the case of Sigul Pandit and the case of the applicant of Monojit Roy is not identical.
did you file a reply in the tribunal?
No, my lord. No, on the at the motion stage, second day that was my lord disposed of.
So what is your affidavit? Let us see. Where is your affidavit?
I have filed that, my lord. That was filed, my lord, on.
Yes, we have it. Which paragraph?
My lord, kindly see. I have categorically stated, my lord, that Sigul Pandit, my lord, was still working as a loco pilot. But my lord, he was decategorized and my lord, he was shifted as a head clerk.
Head clerk.
My lord, that kindly come to the paragraph 4, my lord, of my affidavit, page 3, my lord. Paragraph Code subparagraph 3, my lord, from page 4.
He is still in employment.
Yes, my lord.
He is still in employment.
Yes.
The petitioner is still in employment.
And my lord, that applicant from technical cadre to clerical cadre was transferred.
So he is decategorized in 2010.
Yes, my lord. 18 October 2010.
At that time, he was at par with Shigul Pandit.
Yes, my lord. At that time, his pay was, my lord,
At
higher,
par with Shigul Pandit.
higher than that Sigul Pandit.
Yes.
Higher than the Sigul Pandit.
Yes. So then subsequently he has been promoted in 14.
Definitely, my lord, that Sigul Pandit was in the technical cadre. His pay and remuneration and the clerical cadre pay and remuneration is quite different.
But because he is
And my lord,
decategorized,
decategorized,
to deprive him of his legitimate due.
no, my lord, no dues. That is not his claim.
No, that.
Yes, my
that
lord.
is
Kindly
the
see the
reason.
prayer of the original way.
He is claiming parity with Shugul Rai. He is claiming parity with Shugul Rai.
Yes, my lord.
You are saying that the two cases are not at par. There is a disparity.
Disparity.
Because he has gone in another cadre because of his decategorization.
Decategorization. And that Sigul Pandit was working till as in technical
Correct. So
cadre.
therefore, he has gone in a different cadre. But by virtue of decategorization, can you put him to a disadvantage?
No, not this.
Then
No,
why he will not get what
not,
his
my lord, my
peer is
humble
getting?
and respectful submission, there is no question of disadvantage. My lord, he admittedly he was, my lord, he was taking that as a head clerk post. My lord, due to his physical unfitness to work as a loco pilot, due to
So
the
what is
visual
provision?
problem.
What is the provision in section 20 of the Persons with Disability Act? Let us see. We are asking you whether by virtue of decategorization he can be deprived. You see section
Yes,
20.
yes, my lord, that was not the prayer also.
Now this is something
Yes,
which has come now.
Yes,
This
grateful,
was
Your
not there.
Yes,
Therefore,
yes.
we are asking you.
For a moment, your lordship, kindly come.
No, we take it. Without going further into the facts, we take the facts as you are saying. 2010 decategorized to 2014 promoted in a different cadre. So therefore, because of his decategorization, he is deprived. Can you do it under section 20? Let us see. The other day.
My lord, his prayer for fix the next increment. My lord, for a moment, kindly see.
That is why we are drawing your attention to section 20. Please read what it says. Whether he will get his next increment or he will be
Yes,
deprived.
he is great, his net, he is great.
And if while granting so, will he get it at par with his junior or he will get it before his junior?
My lord, yes, my lord, at par with the junior of the decategorized
So
post of head clerk.
Therefore, what is wrong in considering
My
along
lord,
with
that was also wrong. That at that time of 2010, the
Yes.
pay scale of Sigul Pandit was lesser than the applicant Monojit Roy.
So he should have asked for more.
Yes, my lord, why they prayed for give me another increment?
Yes.
And when they prayed in the year of 2014, 2008, he was promoted in this technical cadre. 2010, my lord, from technical cadre to decategorized and as a head clerk, and he prayed in 2014. And my lord, tribunal directed at the same time consider and to pay. My lord, if tribunal direct me to consider the case, then my lord, at the next line, I have to pay. Then there is no question of any consideration of by the railway authority.
You want to consider, but you don't want to pay.
My lord, if your lordship
Once you
direct me to
consider and
consider
if they
the
have
case, then I have to. My lord,
Therefore, that is the
then
right.
at the same time, if the tribunal directed to pay, consider and pay, then the
Consider
what
and pay.
consideration will remain, my lord?
Consider and pay, the tribunal has said, because the person who was junior to him, he has already gone to the next higher.
At that time, till 2010,
Yes.
that Sigul Pandit, my lord, pay of the Sigul Pandit
Was lower.
is lesser than the applicant.
This is 95 Act, 2006.
My lord, in Sigul Pandit case, one Joyanto, my lord, he got that. In that case, for this reason, he prayed. And my lord, that case of Sigul Pandit was allowed because both they were in the technical cadre as loco pilot. And my lord, the case of the applicant is quite different.
Section 22, 20 or 22. The old act, it is section 47. Must be a similar. Section 22. So when he was shifted as head clerk, he was having the same pay scale.
Yes, my lord. Pay protection was there. That is there, my lord. Kindly see. That protection was given.
Yes, section 20. Have a look at section 20.
My lord, for a moment, kindly come to the page 44. What was their exact representation?
He is only claiming parity with this other person. You are saying he cannot claim parity because now they are in two different wings. But the fact remains that prior to decategorization, he was better off than the other
Yes,
person.
my lord.
So therefore, by virtue of this, can he suffer a disadvantage? You see section 20.
And
we are asking you to
my lord, for a moment, kindly see page 44, my lord. What was his representation? He is praying, my lord, for another increment.
He should, because this other person has been granted by virtue of promotion.
Not by virtue of promotion. For a moment, kindly.
In 14, he has been promoted.
He was also promoted from grade 1 to grade 2 in the year of 2008. And he says that in the year of 2008, my pay fixation was wrongly done, another increment should be given. That was his prayer. It is not that, my lord, due to decategorization, his pay was lesser. That is not the case. For a moment, kindly see, your lordship, page 44, my lord. My lord, through proper channel, subject fixation of the pay on promotion as loco pilot on 2nd February 2008. With respect and I state that understand beg to state that I was promoted to as loco pilot goods with effect from 2nd February 2008. At that material time, I was not given any scope for submission of option, for which my fixation to the higher grade badly hampered. I thus pray before your good self to kindly consider this as my option in terms of serial number 114 of 2008 for the said promotion and refix my pay as per extract rule, as I not provided with my increment on 1/7/2008.
But his prayer before the tribunal, see his
Yes,
prayer
my lord,
before
kindly
the
see.
tribunal.
That is, my lord, at page.
He wants his next
Page
increment.
37, my lord.
He wants his next increment in the promotional post of loco pilot goods.
Allow the
If he had not been decategorized, he would have got this pay. He would have got this next increment of the promotional post of loco pilot goods.
My lord, he is paying for next increment in the post of from earlier post of loco pilot.
No, please see his prayer B and C.
Yes, my lord.
One of the prayer is not acceptable. That does not mean all the prayers
My
will
lord,
go.
for a moment, kindly see the E, prayer E. 1A.
So even if we
Treating
say,
the petitioner as to have opted for promotion.
so we say even if the first prayer is not admissible, that does not make the other prayers inadmissible. We are not asking you to give him anything from 2008. Tribunal has also not asked you to give him anything from 2008. Tribunal has said treat him as par with this person.
Yes, my lord. Kindly consider then prayer B also.
Yes.
Allow the petitioner next increment in the promotional post of loco pilot goods.
Correct.
In the scale of pay of rupees such and such, GP such and such on 1/7/2008.
Because the other person has got it.
That was already given to him in the year of 2008.
Given to whom?
To the applicant Manojit Rai.
Yes.
Next prayer. Fix the pay of the petitioner in promotional post in the scale of pay of rupees 9,300 to 34,800, GP rupees 4,200 in accordance with the rule FR 22A1 with the rule 13 of such and such rule 2008.
This is the only aspect the tribunal has asked you to consider. The tribunal has not asked you to consider the
Yes,
other two
my lord, for this reason, my lord, he have to give one option according to this rule.
For this prayer C.
Prayer C. Prayer C.
No, prayer
and my
C,
lord, his
prayer C is the next promotion. Prayer
prayer
A and B
C
are the
and
earlier
page, my lord, kindly consider together prayer and page 44 of his representation.
Not required. We are only required to see the tribunal's order. Tribunal has not asked you to go into these issues.
Yes.
It is all in the head of the authorities.
Yes, my lord. So, my lord,
the tribunal has only said that his promotion has been given to this person. You consider him at par and you give it to him.
Yes. At the promotional post,
Yes.
my lord, he was given, my lord, every benefit. It is not his case.
No.
My lord, kindly see what pay scale was given.
You have given him 9,300 to this pay of 9,300.
Yes, my lord.
Grade pay 4,200.
Page 66.
With effect from the
Yes,
date.
yes.
Where is that?
Page 66, my lord. My lord, page 63, first line. PA revised on 1/7/2013 rupees 18,000 plus 4,200.
Where can we see that he has been granted the scale of 9,300? Grade pay 4,200. Where is that?
PA revised 18,910 plus, my lord, that is the grade pay 4,200.
Where is that?
That is total, my lord, 23,110, my lord. That is with effect from on 1/7/2014. My lord, page 66, my lord.
1/7/2016.
Page 66 of this repetition, my lord.
Yes, pay revised. 18910.
Pay revised, yes, my lord. On 1/7/13 rupees 18,213 plus grade pay, my lord, that is 4,200 is equal to 22,430 on 1/7/2013. Next line, my lord. Pay revised.
Every year his pay is, revised.
Yes, my lord, they are in
the annual increment, sir. This
annual
is not
increment.
grant of the. I don't say that this is the promotional post. This is an annual increment. Every employee gets it, even if he's in the same post. This is not a revision.
My lord,
this is the annual increment.
He is entitled for the benefit for the post of loco pilot till the date what he was worked as a loco pilot.
So now you are coming back to that. That is what we are saying. So we are asking you, why don't you look at the provision of the act that we are trying to say? You are unnecessarily arguing on things which are irrelevant. The only thing is that the person with whom he is claiming parity is on a post which he cannot hold by virtue of decategorization. So therefore, can he be deprived? We are asking you repeatedly, go through section 20. Then only you address us on this point. Otherwise, you can't say he is not at par. If he has been decategorized by virtue of a medical examination and he cannot be made to suffer, you see the provision of the act. These are nothing. This is annual revision. Every employee gets an annual increment. This is no revision.
My lord, in considering that act, also, my lord, my humble and respectful submission is this.
You
my
don't
lord.
want to examine the act.
My lord, his representation says, my lord, otherwise.
So you don't want to examine the act, then we'll pass the order. Then there is nothing left. We are asking you to go through the provision.
So, my lord, then I have to come, my lord, on the next day, my lord, considering that.
So therefore, we are saying, just see why we are saying something. You please examine. Don't get so stuck to your case that you will not even examine the statutory provision. You see the provision. Assist us with that. The only reason for your considering his claim not to be at par with the other person is because he has been decategorized. That is the only reason. Now, by virtue of decategorization, can he be made to suffer? He cannot. That's not. There is a statutory provision. If it was in 2014, then under the earlier act, section 47 it will apply. If he is after 2016, then in the new act, section 20 will apply. You please see both the provisions. Yes, heard counsel for the petitioner.